Okay, Assalamualaikum and a very good afternoon. Okay. Remember our talk on the 11th of June where I was disrupted by the internet connectivity. Okay, so I had problem with the internet on that day. Okay, so I will now I record everything all over again. Okay, so for your reference. Okay, so first of all, I would like to thank Kausal who keep on reminding me of this talk. Okay, so the talk that I'm going to deliver today is on the legal aspects in organization, the importance of employment law, which we did, I think, halfway on the other day. Okay, so that's my name. Okay, I'm Sharija Cik Shari. So I'm a lecturer, okay, in FPAP. Okay, I'm teaching commercial law, company law, employment law, and safety and health. Okay. Okay, so this is the framework of our today's discussion. Okay, so I divided into 5 subtopics. Okay, so for recording purposes, I will have it into 4 parts. Okay, the first one will be part A on which is the current recording. Okay, where I will introduce to you what is law and the background of Malaysian employment law. Then we go into the second part that is on the terms and conditions in a contract of service. This will be the second part. This will be the first part. And the third part, I will brief you on manager prerogative. Okay, so what is managerial prerogative? Okay, then finally, I will go into the current issues in the workplace. Actually, there are a lot of current issues, but I just chose a few. Okay, and I will conclude the session. Okay, so this will be part 4. Okay, so as I said in the last class, when we met online the other day, why do we need employment law? Okay, as I said to you that Shackleton in 1975 said that employment law why do we have to go to work in the first place? Because it is a central feature of modern industrial society. It occupies much of the time available to most people for the majority of their lives. And the economic rewards obtained from it determine an individual's standards of living and to a considerable extent his social status. Even though Shackleton and Davis had made this statement in 1975, but I believe that this statement is still relevant for our until today. So it is right for him to say that when we work, it occupies much of our time. And for most of us, majority of our lives are spent at workplace. So now let's say on assumption that you start working at the age of 23 and you will work until 60 years. And God knows when we will pass away, we never, so let's say this is 23 until 60 years. Now let's say we live until, let's say, 80. Some might be lesser, some might be more, depending on God's will. So meaning that we spend most of our life at a workplace. And how many of us are lucky enough to retire early, let's say at the age of 40? At the age of 40, you have already self-sufficient, maybe through your business or your saving or whatsoever, or inheritance. So you do not need to work anymore. So then they are lucky people. But for most of us, we have to work. And upon reaching a retirement at the age of 60, depending on your nature of job, I know that in academic, let's say in the United States, they will still continue working until they die or until they do not want to continue anymore. And let's say in Singapore, the retirement age is 65. In Indonesia, it is 65, And I noted that most academicians, even though they work after their retirement, it is not for money per se. It is more because they would like to share, with the youngsters, with the the newbies, okay, the knowledge that they have, okay. So, but some, okay, to others, maybe they work because they need money. Because if they do not have, if they don't work, they do not have pension, they neither do they have EPF, or if they have EPF, the money has already run out. Okay, so they need to work. So meaning that whatever it is, okay, whether we work for money or we work, okay, to a certain extent of our life, okay, why we work? Because of the economic rewards. And I don't think that there are many people who like to work for free, because we still have, we have our commitments. We need, okay, basic commitments, for instance, house, okay, your daily substance, okay, how daily subsistence, how you are going to fend yourself, okay, your meals, okay, and so forth, okay. And when we work, okay, the economic reward will determine an individual status and individual standards of living. Okay, that is absolutely right. Okay, let's say if you are a degree holder should earn a certain amount of money, which is supposed to be higher than those SPM school leaver. Okay, so I'm not trying to degrade those with SPM certificate, yeah, but generally those with degree will be paid more. Okay, so to the certain extent, it will determine the social status as well. Remember, those days, okay, in 1970s, okay, if a man, if a guy is going to ask for a hand, for the lady's hand of marriage, okay, bertunang, yeah. So if you go to the girl's house, okay, some parents will ask you, if you're a teacher, sekolah rendah or sekolah menengah, because those days, okay, the non-graduate teacher will teach at primary school. The graduate teachers will teach at secondary school. So the teachers at secondary school will earn more than those in primary school. That was those days. Nowadays, okay, even though there are graduates, okay, graduate teachers, but if they opt to teach primary, then they will teach the young ones at the primary. So it does not matter anymore. Okay. And why? Okay, what is employment law? Okay, so it governs the relationship between employer and employee. Because if we do not have any law that governs our relationship, then it will be chaotic. Okay, so meaning that law of the jungle will apply. Okay, the those with power will suppress the most junior. Okay, those with more money will oppress those who are poor, and so forth. Okay, so the employment law is aimed to safeguard the interests of the employer and the society in general, and an employer and employee in particular, because all of us are either employer, okay, or employee. Most of us are employees, okay. So let's say if the relationship between employer and employee is not in a good condition, okay, then then it will be what we call here as hostile workplace, okay, or the workplace is not harmonious anymore. So we will not be happy to go to work. We keep on looking for new workplace, okay. So what will happen if, for the employer, let's say the way he or she treats the employee so bad, okay, so the employees, the turnover among the employees very high. Maybe he did not realize that when the employees leave the company, they will bring along with them the knowledge that they acquire at the workplace. So the employer will have to train a new employee again. And after some time, the new one leave the company for some reason, and it will be never ending. Okay, so that is why if you treat your employees well, they will stay with you. Okay, for example, I've done a research, in hospitality industry. Okay, I met this guy, okay, who used to work in a 5-star hotel. Now he's working at a 3-star hotel. So I asked him, what makes you okay, chose to work in a 3-star hotel when you previously worked in a 5-star hotel. Okay, so the salary differs because the salary at 5-star hotel is better than the 3-star hotel. But according to him, money is not everything. According to him, one of the reasons why he left 5-star hotel because being a Muslim, he's not comfortable in serving liquors to the to those who goes to the okay to their F&B outlets, okay, the club or the so that is why he chose to work in a 3-star hotel, which is certified as a Sharia compliant hotel. So in this 3-star hotel, he does not have the guilty conscience. Okay, so and then what makes him happier is that he got a chance to perform Friday prayer every week. Okay, so what I'm trying to share with you is that sometimes it is not about money. Yes, money is very important, but it is not the most importance in our life. It might be, so there are a lot of other things. Maybe you cannot relate with what I'm saying to you now because you have never start working yet. Okay, so once you start working, after a few years, then you'll be able to understand what I'm trying to convey here. Okay, as you go along, okay, the most important, okay, the most important part in your workplace is you're happy with the workplace. You're happy with your colleague. You're happy with your friends. Okay, then only then we go to the salary. Okay, harmonious relations in the workplace, I've already explained, and enhance the company's productivity. So let's say if the workplace is harmonious, okay, harmonious does not mean that it has to be perfect, okay, because we are all humans. Okay, so but at least, okay, employees do not have to drag themselves to go to work in the morning, okay? So maybe they look forward to go to work. They look forward to meet their colleague and so forth. Okay, so but sometimes we do have differences in our opinion. So that is acceptable. Okay, so let's say if the company, okay, the employees in that particular company is happy with what's going on in the workplace, therefore the productivity will be enhanced. So if the productivity is enhanced, then the profit will also increase. So when the profit increase, the company has to pay tax more to the government. So overall, our nation income will increase as well. So that is why at the beginning I said that employment law is closely related to the society. Okay, now for the introduction, okay, what is law since all of you are non-law students, okay? Law, okay, we can simply, say that it is a rule of action to which men here includes women, yeah? Men are obliged to make their conduct comfortable or command enforced. So there must be, okay, must be a rule of action and which is enforced by some sanctions. Okay, so meaning that if there is a law or rules, it has to be enforced. And okay, there must be sanction for those who are not complying to the rule. Okay, when you talk about sanction, it's not necessarily about punishment. Okay, so put it this way. Let's say, okay, I came across this in my research as well. Okay, many employees, okay, in a workplace, especially in manufacturing or construction, they do not want to put on PPE. Okay, personal protective equipment. So it could be, if in construction, it could be hard hats, safety boots, If in manufacturing, it could be safety boots, it could be glove, it could be eye goggle, ear goggle, and so forth. Okay, so sometimes employees, okay, they did not want. When I ask them, why don't you put on your PPE? They have a lot of excuses. Okay, because they do not understand why they have to put on the PPE. Okay, first, okay, the most complaint was that, oh, it's heavy. I'm not comfortable. Okay, so when I talk to the employer, okay, when I talk to the employer, how do you address this matter? Okay, so sometimes, okay, they say that, or they just keep on advising. But to me, okay, you can, okay, as an employer, okay, employer has two choice. The first one is to, okay, either you give stick, okay, or you give carrot. It's up to the employer. So this is sort of enforcement, okay, that, okay, let's say if you give stick means that you punish those who do not put on, those who do not put on PPE. But the punishment must not be, I mean, the punishment, okay, the amount of compound whatsoever, it has to be in the company's book, in the company's manual, and the employees must be informed of the consequences if they do not put on the PPE earlier. Okay, you tak boleh malam ni buat rule, besok enforce, tak boleh macam tu. You buat rules and then you put it on the notice board, put it in the company's manual, and okay, you have like awareness program among the employees. Okay, only then you enforce. Okay, so if you, okay, some companies they use stick, meaning that if you don't put it or you don't put on your PPE, I will impose the fine. It could be RM1 per day or RM5 per day. It's up to the company. So, but you have to do it. You know, the minute you see that there is non-compliance, then you can impose, okay, such fine. Okay, but some companies, they do not want to fine the employees. Instead, they will have, okay, the list for those who use PPE without fail, meaning that every time they memang guna je PPE, then that person is rewarded. So that is carrot. So how do you reward? Up to the company. Maybe give 1 month's bonus or give free holiday or whatever, okay, of hamper, you know. And the other employees, when they see that their colleague is being recognized, okay, then they would like to be recognized as well. So then later on you will see that more and more employees will put on the PPE. So this is what carrot and stick, okay? So our employees have basic rights in the workplace, including the right to privacy, fair compensation. Okay, so we are not in Victorian era. In Victorian era, okay, that you only have master. Master is the employer, and the employees are known as servant. We cannot question, okay, we have to toe the line, we have to do everything the employer asks, the master asks us. To the extent the master control how we do our work. But nowadays, the employer did not control. They do not control how we do our work. All they want to know is that we get our job done. Okay, they want to see the end result. Okay. So before I start explaining on the employment law, let me just, okay, brief you on the sources of nation law. Okay, why I have to explain it? Because, okay, I'll be referring to cases. Okay, I will also be referring to statutes. Okay, so in Malaysia, the sources of nation law, okay, we have, okay, sources from the written law, unwritten law, and Islamic law for the Muslims. Okay, for unwritten law, for written law, okay, the highest of all is federal constitution. Then you have state constitution. Then you have delegated constitution. Apart from this, we also have statutes. Okay, we also have statutes like Employment Act, Occupational Safety statutes. Yeah, statutes. Occupational Safety, OSHA 94. Okay, or EA. Okay, EA 98, yeah, EA 95. Okay, so these are statutes. Okay, so it has to be debated, okay, in the parliament. If it is federal law like OSHA and okay, it is at the parliament level. Okay, and if state constitution or state law, it will be debated at the state assembly. Okay. Okay, so here, okay, then unwritten law. Unwritten law does not mean that it is immoral. It does not. That is not what is meant. Unwritten law It's okay. Why it is known as unwritten law? Because it is not debated at the parliament or at the state assembly. So unwritten law can be in the form of customs. What are the practices in our company or in that particular industry? And then we have English law. Okay, we are allowed to refer to English law provided that there is lacuna in our law, meaning that there is a loophole in our law. However, the English law that we can only refer provided that there is lacuna or loophole, and the law that we imported from UK or Australia, any Commonwealth countries, it has to be amended to suit our culture. Then we have judicial precedents. Judicial precedents here refer to cases which have been decided in the court, in the court of law. Then you have Islamic law. So that is sources of Malaysian law, because I'll be referring to a few cases and I'll be referring to Employment Act. So Employment Act is under written law because you have to, before it is created and before it is amended, it has to be debated at the parliament. Okay, now I'm going to explain the hierarchy of courts. Okay, why do I have to explain this? Because if you were to read the slides, you'll come across the term as High Court. You'll come across the term as Court of Appeal. So if you do not know where they stand, so you'll be confused. So in Malaysia, you have superior courts. With superior courts is consists of Court of Appeal and Federal Court, and also High Court. There are two High Courts in Malaysia. The first one is High Court of Malaya, and the second one is High Court of Sabah and High Court of Sarawak. Then you have subordinate courts. Subordinate courts here refers to Sessions Court, Magistrates Court, and if it's Semenanjung, Penghulu's Court. In Sabah, you do not have Penghulu's Court, but you have Native Court. Sharia Court and Juvenile Court, they are special court. So when it comes to judicial precedence here means that, let's say in a certain case, let's say the case is at Sessions Court. So before the Sessions Court judge can come up with a decision, he has to refer to the decided cases above him. That is, whether there is any similar issues being tried in High Court or in Court of Appeal or in Federal Court. So he's bound by the decisions from the higher court. So that is known as judicial precedence. If the case is tried in the High Court, so the High Court judge will have to refer whether there is such issue being tried in the Court of Appeal and Federal Court. So if there is similar issue that has been decided in the Court of Appeal, so High Court of Malaya will have to follow the Court of Appeal's decision, unless and similarly, that's how it works. The judicial precedence. So now let me explain the background of Malaysian employment law. So as I said in our last meeting that in Malaysia, our employment law is based on, or our industrialization system is based on tripartite. Tripartite means that there are three parties involved. There is the government, employer, and employee. So these three parties will have to discuss before a law pertaining to the employment or anything concerning employees. The government will discuss with the employer and the employee. For example, when we come up with a minimum wage, so the government sought the opinion from the employer, which is MEF, Malaysian Employers Federation. And for the employee, it is MTUC. MTUC represents those employees in private sector. If it is in government, it is QPEX. So it has to be they have to sit together and discuss, okay, what are the best solution for a particular issue. Okay, and every year, okay, they will go to Geneva, okay, to ILO, okay, to this, okay, to represent Malaysia. Okay, so there is some misconceptions. Okay, so many employers think that they can summarily dismiss or terminate an employee. Okay, for instance, let's say summary dismiss means that you just dismiss by just giving notice, but you do not give any reason. There is no reason attached to it. Okay, I will explain that. Okay, and for a probationer, it's okay. There are also many misconception that a probationer is not entitled to annual leave, sick leave, and paid public holiday. And there is also misconception that employer can terminate a probationer, okay, within 24 hours. Okay, but within 24 hours, you have to be very careful, because if you allow the employee to, okay, submit the resignation within 24 hours, then you can terminate employee within 24 hours. However, for employer, they must give a justifiable ground. Otherwise, it will become summary dismissal. And summary dismissal is not, I mean, if you go for summary dismissal, mean that you just terminate an employee without any justifiable ground, the employee can go to can go to either civil court or industrial relations court to file a claim for wrongful dismissal. Okay, and there is also many misconception. Okay, especially in small enterprises. Okay, they think that between the employer and employee, okay, there is no contract of service because they do not sign anything. Okay, let me just share with you that, okay, a contract need not necessarily be in writing. A contract can also exist even though it is done orally. Let's say, for example, in small, let's say, sundry shop, kedai runcit kan? Let's say you ask them, you need a shop assistant, and then you, posted an advertisement, at your window that you need an assistant. So that, let's say that is a, let's say Amina, who's looking for a job, came and see you. Then when you look at Amina, you look at the way she carries herself, that at least she has let's say SPM school certificate. Okay, so you decided to employ Amina here. So then you just say, okay, Amina, tomorrow you start working. Your salary will be 1,000 from minimum wage, 1,500. I'll pay you at the end of the month. That amounts to a contract already. Okay, so now let's say Amina starts working with you. Then let's say after 2 months, Amina would like to leave. Then Amina can, normally small enterprises, they do not have contract. They do not have contract in writing. Okay, so if you do not have contract in writing, therefore, the law, the applicable is, if you are in Semenanjung, that will be Employment Act. If you are in Sabah, Sabah Labor Ordinance. If you are in Sarawak, Sarawak Labor Ordinance. So between you and Amina, there is no contract. There is nothing when it comes to termination. Therefore, Amina can refer, let's say Amina is in Semenanjung. So Amina, based on Employment Act, Amina, if there is no period, or no time frame agreed between the employer and employee pertaining to termination, therefore, Section 12 will be applicable. And if you just work less than 2 years, your employee will have to give 4 weeks notice. Okay, I'll come to this later. So Amina can always leave you by just giving 4 weeks notice. But you, as the owner of the shop, cannot give 4 weeks notice without any reason to Amina. Okay, if Amina knows her right, she will go to Industrial Relations Department, okay, and file for representation for wrongful dismissal. So for the, okay, for the employer in Malaysia, employer, okay, must give the reasonable ground why you are terminating that employee. For instance, maybe lack of discipline, but you must have proof. You must, in the file there must be how many times and so forth, and whether you have already cautioned Amina that her her performance is not up to the standard. It has to be in the file, because that will be an evidence on your part. So, or you can say Amina is absent without reason, then you can terminate her, but it has to be justifiable ground, meaning that alasan yang munasabah. And there is also misconception that employer has the right to hire and fire. As I've already mentioned just now. When it comes to hire, yes, it is always employer's right to hire. Let's say you as an employee, let's say you as an employer, let's say you are the HR manager for a big company. If you want to hire A, nobody can question you, even though B's result is much better than A, but you hire A no one knows why you hire A, but you hire A for your own reason. You must have reason why you hire. So nobody can take you to court for hiring A. However, when it comes to fire, it can only be done if you have just excuse, justifiable ground, or just ground. Means alasan munasabah. Let's say you fire that person because unreciprocated love, cinta yang tidak berbalas, then it is not just excuse. That amounts to unjustifiable ground. So unreciprocated love, cinta tidak berbalas, cinta sebelah tangan saja. So you can, let's say you as the boss, you like that girl. So you approach her, but she rejected you, then you fire her. You terminate her services. So that is not that is wrong. Can you say that I'm not a law student, I did not have law background, so I should be excused? You cannot do that. Why? Because in legal, there is legal maxim. Maxim here means in Malay like pepatah lah, pepatah. Maxim. There is a legal maxim that says, ignorantia legis neminem excusat, meaning that ignorance of the law excuses no one. So meaning that it is a legal principle holding that a person who is unaware of a law may not escape liability for violating that law merely because he or she was unaware of its content. So you cannot give an excuse that, oh, I'm a psychologist student, I don't know this, because it is assumed that you must find, you should have read, you should have asked opinion from the experts how you should go about it. So now that's the end of part 1. I will continue with part B later. Thank you very much.